Sound good? All righty, well, welcome everyone. My name is Patrick Lopez. I'm the Associate Director of Career Services at UNM Law and been heavily involved with the Late Border Justice Initiative, which is a brand new project we've been working on and we're really excited about. And today we are very excited to present part 2 of this ongoing series on immigration law. And we have some excellent guest speakers today, which I'll introduce briefly. A couple of housekeeping matters. We would ask that unless you're one of the speakers or asking a question, to mute your audio, and then you can unmute if you're going to, engage in the conversation. Also, if you would like a copy of the slides or have any questions regarding sort of housekeeping matters, you can go ahead and email me. My email address is lopezp@law.unm.edu. And I believe we'll be providing my address again later. Also, if you're interested in getting involved in this project, we're growing the project. We're looking for people to get involved in various capacities, whether law students or practitioners. Email me and we can work on how you can get involved. So with that said, allow me to introduce our guest speakers today. We are, again, very fortunate to have Jesse Miles and Daniel Caudillo with us today. They're going to present some very interesting information. Jessie Miles is an alum of UNM Law, and we're very proud to have her. And she's been very involved in our project thus far, giving us a lot of guidance and information that's important. She's worked on many issues, on border issues. She's based in El Paso, working on legal, political, and policy work. She's a co-founder of the Borderline Immigration Council, which is a binational coalition of attorneys, nonprofits, and NGOs working on human rights at the border. And she's written several articles on the border issues that are very important. So we're very, very glad to have her. And our other guest speaker is Daniel Caudillo, who's also based in El Paso and works exclusively in immigration law, removal defense, family immigration, employment. He's also served on many different ALA committees, including conference committees, the ethics committee, which is very important, which we can rely on at this point. And he's also an excellent presenter from everything we've seen from him. So without further ado, I'll turn the time over to Jesse and Daniel, and they can take it from here.
Awesome, thank you, Patrick. I just wanted to mention something that you did not mention, but we are recording this, is that correct?
I believe so. It was.
Yes, we are recording this. Thank you.
Great. That way everybody is aware this is being recorded. Okay, so thanks guys, thanks for having us. Daniel and I have worked together since I came down here to do immigration law in 2014. And he is the person that I go to when I don't know the answer to something, so I'm very happy to have him to help present this day. I wanted to start, let's see. There we go. I wanted to start just by talking about the goals of the CLE. And when Daniel and I were putting this together, what we really wanted to do is make sure that we were providing kind of just basic procedure for removal proceedings for attorneys who are, already practicing maybe in other areas, who are interested in getting involved in practicing in immigration law. There's some big differences in terms of how removal proceedings are conducted. So learn basics of removal proceedings. We also wanted to orient attorneys and students to the relevant statutes and regulations that have to do with removal proceedings. So immigration attorneys talk about the Immigration and Naturalization Act, or the INA. And so that's how you'll see all of our statutes being cited in the presentation, but those are also located in the US Code. But we provided those. We won't go into a lot of detail, but I wanted to provide those on the slides so that folks can write them down, or we'll also give you a copy of this slideshow so that you guys can look up the relevant statutes that you'll need to know to practice immigration law. And then finally, to get rid of some, I say some, of the fear of practicing in immigration law. A healthy dose of fear is good, particularly during these very tense times. So those are the goals of the CLE. Before I turn it over to Daniel, talk more in depth about removal proceedings, I did want to just kind of orient us to the structure and the authority of immigration court, where they get the authority. Congress actually has the authority to write rules and to determine the rights of immigrants and how immigration works in the United States. And so they wrote the Immigration and Naturalization Act. However, the executive branch is the branch that is responsible for enforcing those laws. And so this is how it's structured. Under the executive branch, we have the Department of Justice, which right now is headed by the Attorney General, Bill Barr. And they oversee the Executive Office of Immigration Review, which is where immigration courts are housed. That's where the immigration courts are. That's also where the Board of Immigration Appeals, which is the appellate body above immigration courts, that's also where it's housed. And so when we're talking about things today, we're talking about administrative law, right? They're an agency. These are administrative courts and agency courts. Also under the executive branch is the Department of Homeland Security, and underneath the Department of Homeland Security are USCIS, which handles affirmative applications for immigration. So, if you're wanting to get a student visa, or if you're wanting to apply for adjustment of status or something like that, you're going to go through USCIS. ICE is also under DHS, and that's Immigration and Customs Enforcement. They enforce immigration law and policy within the interior of the United States. And then there's also CBP, or Customs and Border Protection, and they enforce customs and immigration law on our borders. So that would include Border Patrol, and then also, customs, which is who you encounter when you come into the United States at a port of entry. The prosecutor in an immigration court is going to be an ICE attorney. So many times you'll hear us talking about ICE says this, ICE says that. Those are the ICE attorneys that are like the prosecutors in immigration proceedings. So with that said, Daniel, how does somebody end up in removal proceedings?
So individuals can end up in removal proceedings in several different ways. One of them is, and that's encountering many of those different agencies that Jesse just mentioned. One of them is CBP. So that would be Border Patrol, CBP at a port of entry, at an airport, upon re-entering the United States or entering the country unlawfully. They can also be interviewed after being arrested and committing a criminal act. For instance, if I'm an undocumented individual and I get arrested in Hobbs, New Mexico for a crime, ICE will usually check in there. They have officers spread all over the country where they'll check the individual, check whether they have status or not, and then ICE will then place them into removal proceedings. USCIS, the benefits arm of the Department of Homeland Security, also has the authority to initiate removal proceedings. And that changed significantly in October of 2018 when they issued a new policy allowing them or requiring them to initiate removal proceedings after someone is denied a benefit for a long list of specific applications. So one of the things you have to think of now is, what's the risk of me being denied and then placed into removal proceedings on top of the previously. And of course, anyone with prior deportation orders will also be, could also be facing those problems. I think on the slide is also visa overstay. So individuals that overstay their visas obviously become removable as well from the United States.
And Daniel, how are removal proceedings initiated? How does that happen?
So this is done through a document called the Notice to Appear. The agency that's going to be charging that individual creates, or whoever has the authority to issue the Notice to Appear, it's an allegation or a charging document. It has a list of allegations. You're not a citizen or national of the United States. You're a citizen or national of Mexico. You are you enter the country on this date with a B1, B2 visa, a tourist visa, and you overstayed that, or you entered the country without inspection. And then it has a charge which says under what statute, under what law, you are either removable or inadmissible to the United States. That document gets charged or filed by that agency with the EOIR, the immigration court. And once that gets done and gets done properly, then you get, you're now in removal proceedings.
That is what happens. So you get your form I-862. That's what the notice to appear is called. That's the form, the actual physical form. And that means your client has been placed in removal proceedings. So before we talk about the NTA in a lot more detail, let's just go over kind of the bones of removal proceedings. Removal proceedings is how I explain it to my clients. Removal proceedings are 2 steps. The first step is the removal component of the proceedings. And during that phase of the case, the Department of Homeland Security or the ICE attorney has to prove that the immigrant is removable or deportable from the United States. And we'll talk about a little bit about the difference between those 2 things. But for the purpose of this, we'll use them interchangeably. So DHS has to prove that the person is removable from the United States. Once you have met that burden, then you move to the second portion of the case, which is the relief portion of the case. And there are several types of relief that a respondent can apply for. Also in immigration proceedings, just so you guys are aware, the immigrant who is in proceedings, we call them the respondent. And then finally, after the relief portion, the immigration judge will issue a decision. That may be appealed within 30 days to the BIA, which is the Board of Immigration Appeals.
And I often use the example of criminal case. A criminal case goes through the guilt innocence phase and then the sentencing phase. It's very similar. Is the individual removable or not? And then the sentencing phase would be the relief. Are they eligible for any waivers or any way of remaining in the United States? And so, and then the appellate process, you know, continues after that. And so for those of you that have practiced in criminal law, that's an easier way, I guess an easy way to explain to individuals that this is what's going to happen in immigration court.
Yeah, that's right. Okay, let's talk about the NTA. So the notice to appear, which is the charging document, that gets lodged with the immigration court. So sometimes you'll have a client that might have been served with a notice to appear that they were given by ICE, but until it's actually filed with the immigration court, removal proceedings have not commenced. So once the NTA is lodged with the immigration court, at that point, the respondent is in removal proceedings. I'm not going to go too into detail about these, but it's really important that you know that the notice to appear has to provide these things. It has to provide notice about the nature of the proceeding, the specific alleged violations of law, and some other things. Also, it has to be signed by an official who's authorized under this regulation. The reason that I want to mention this is because many times a notice to appear can be deficient in one of these ways, and that can form the basis of a defense to immigration proceedings. Now, it's not clear how far that defense will get you because of some things that have happened in the law, but you always want to review your NTA for those things. So here is a redacted notice to appear. This is what it looks like. So it has, the subject ID, their date of birth, the file number up in the right-hand corner. That's where their A number or their AN number is what it's called, will be. The respondent's name, and usually in their address. Now you can see in this case, this client was actually in the Otero County Processing Center. It's kind of hard to see. I'm sorry about that. There we go. Let's see if I can you guys see that better? Daniel, did it zoom in?
It did.
Okay, great. So you can see here that the client was detained at the Otero County Processing Center in Chaparral, New Mexico. And then you'll see these 3 boxes, which we'll talk about in a second. This is the designation of basically how the government has designated your client kind of what their legal designation is under the law. And then these 4 things are kind of typical allegations that you would get on what we would call an EWI case, or an entry without inspection. So the first 2 will be alleged have to do with alienage. And, you know, DHS has to prove that your client is not a citizen of the United States and is a native of another country. If they cannot prove that your client is not a native of another country or citizen of another country, then they haven't established jurisdiction over your client. So these 2 allegations are really important. And I think a lot of times we kind of gloss over how important those 2 are. And then the other 2 allegations, and sometimes there will be more, have to do with how this client specifically came into the United States, or how it was alleged that he came in. And so it says, you know, he arrived at an unknown place on or about this date, and that he was not admitted or paroled. And then down here, you'll see this is the legal charge that they're charging against this client. It's 212A681, which is the EWI charge, or the entry without inspection charge. This means that the client came in at a place other than that which was designated as a port of entry. Here at the bottom, you'll see that there should be a notice here of the date and the time of the immigration proceeding. This has been the subject of a lot of litigation in the last 2 years under a case called Pereira. I'm not going to go into more than that because that's like a whole other CLE, but just know that this is important for you to look at. And then you can see over here all of these different advisals. So specifically, failure to appear is really important, yeah, failure to appear, and then it goes over kind of some of the rights that they have. And then finally, here's the certificate of service to your client. Whether or not your client signs this or not, it doesn't matter. Many times your client will refuse to sign, and it'll just say they're refused to sign. So that is what a notice to appear looks like.
And Haley, to answer your question, you're correct. Lodging means filing. So when that document is lodged or filed with the immigration court, the court will actually time and date stamp it, and they'll open up their own file in the EOIR system. And that's how those proceedings are began.
Yeah, and thank you for answering that, Daniel. I actually cannot see the chat because I'm running the PowerPoint. So I'm going to defer to Daniel to pick out if a question needs to be answered now. Otherwise, if it's kind of a more detailed question or something like that, we'll leave it to the end. That's a great clarification question. Those are really, really important. Okay, so Daniel, what happens when you go to an immigration hearing?
So once you start, there's different types of hearings. There are master calendar hearings, there are individual hearings, there are bond hearings. As you can see just from this photo, the immigration courts are not like any other court, like a criminal court. They are very informal. They are not as formal as many other, for instance, a federal court. Generally, there's going to be a judge, a clerk, an interpreter. You're going to be sitting at the table. You're not making arguments, or you're not arguing before a jury. The immigration court proceeds only before an immigration judge. And so the case is decided by that judge in both forms of removability, inadmissibility, as well as the relief that the respondent might be eligible for. Now, oftentimes, as you can see from the photo, you'll be sitting there with the government attorney, and your client will be on a television screen from a long distance where your client may be detained. The purpose behind detention in remote areas is not readily admitted to, but it's definitely frustrating for legal representation. And so that's something to keep in mind, is that when you're practicing, you've got to have access, or you can often have difficulty having access to your client. But
one thing I wanted to mention, Daniel, too, that you alluded to is the immigration judge, right? So an immigration judge is actually, I have to be careful about how I say this. They're not a judge in the traditional sense. They're not an Article 3 judge, for example. They're actually a hearing officer. So they're an attorney that gets appointed to be a hearing officer in the court. And that's kind of one of the reasons that this is less formal. They look like a judge. They wear robes, and you of course address them as Your Honor and Judge. But I think that's important to note. It's also important to remember that they don't actually have contempt power. And that's important because if an immigration judge issues a subpoena, for example, which you can get them to do in certain circumstances, getting them the ability to enforce that subpoena can be very difficult because immigration judges don't have any authority over anyone who isn't an immigrant or isn't a foreign national.
And it's important, that is an important point. You've certainly seen in the news how there's been a push, not only by representatives, attorneys like ourselves, but the judges and the judges union to get independent courts. And it would be to give those judges more authority, more independence in moving forward with those court proceedings to make them more just, essentially. Every respondent in removal proceedings has a legal right to an attorney, to counsel. The government does not provide an attorney for them. They are not paid. In immigration practice, there's also BIA representatives or accredited representatives that have gone through certain training and get certified by the Board of Immigration Appeals. And there's also clinics that offer assistance and get approved to offer representation in limited manners. At the bottom of that slide, they also mention the effective assistance of counsel. There's a process to proceeding against or to argue that an individual did not receive effective assistance of counsel, and it has to be adhered to fairly strictly in order to be successful. But as I mentioned, there's different types of hearings. The master calendar hearings are the first time the judges are going to see the case. They're going to meet the attorney, the individual. They call them master calendar hearings. They're often held in group settings where you can have 10, 15 respondents in one room, all of them getting placed under oath, all of them being advised of their legal rights and responsibilities in those proceedings, all at the same time. It's very similar to a docket call in many ways, but there's no individuality. But what you're doing at a master calendar hearing is you're addressing the allegations in the notice to appear. You're addressing the charges. You're arguing whether or not the individual is removable or not. The judge will often ask for determination of those allegations. They'll issue that based on your admissions, or if the government submits the evidence required to do so. They'll designate a country for removal in case that individual is in fact removed. And then you'll begin working on relief applications or waiver applications. You'll have multiple master calendar hearings until they schedule it for a merits hearing or an individual hearing, which is essentially the trial in immigration court.
Okay, so let's talk about step one, which we briefly addressed. So step one is to determine the removability or the deportability of your client. And as I said, DHS has the burden to prove the allegations in the notice to appear and the charge of removability or deportability by clear and convincing evidence. Okay. I'm going to get to the next. The other thing that you will want to look at when you're getting ready for your removability or your deportability part of the case is determining what the charge is according to the notice to appear. So quickly, if someone has not been admitted to the United States, and that means that they didn't come in on a visa, that they didn't come in at a port of entry, right? They're either an arriving alien, somebody who was kind of allowed to come in just for a short amount of time without a visa, or somebody who came in without inspection between ports of entry. They will be subjected to INA 212, which are the grounds of inadmissibility. These are the most common, these two are the most common grounds to find someone removable under 212, and that's present without admission or present without documents. If someone has been admitted before, so maybe they came in on a tourist visa and then they overstayed, or maybe they're a lawful permanent resident and they've committed a crime, then the grounds of deportability will apply to them, which are located under INA 237. Typically, those are, like I said, criminal related, or they're alleging a visa overstay. So DHS has the burden to prove deportability by clear and convincing evidence. And that starts with making sure that they can prove alienage. As I said, if they cannot prove alienage, if they cannot prove that your client is from another country, then the court does not have jurisdiction over your case. You can ask to terminate the proceeding, which is like a dismissal. And sometimes the judge will give them more time, unfortunately, and sometimes they won't. Sometimes they will terminate the case based on DHS's inability to prove that this person is from another country. If they do provide evidence of foreign birth, so usually they provide a birth certificate for your client, which is super easy for them to get from the Mexican government usually, or really any government, then that gives rise to a rebuttable presumption of alienage. And the burden then shifts to the respondent to prove that that's not the case. So most of the time, you can't do that. There are some certain circumstances where you'll have a client who maybe was born in another country, but they're a US citizen, and you're able to provide proof of that, which again is kind of a longer process, but just know that, there is a way for you to rebut the alienage of your client if you have proof of that.
And Haley, you asked a question as to what happens whenever a case is terminated. Very simply, if a case is terminated, then the respondent is no longer in removal proceedings. The government has the authority to appeal that decision. Unfortunately, unlike in criminal matters, there is no double jeopardy protection. And so the Immigration and Customs Enforcement, or CBP, whichever the agency, has the right to refile a new notice to appear once they do obtain the evidence that would sustain the removability.
Yeah, under certain circumstances, you can argue for collateral estoppel, but again, that's a little bit more kind of in the weeds. But yes, termination is good, particularly if your client is detained and they need to get out. So if you have some proof, if you have some proof that your client is not a national of another country or is a U.S. citizen, you should absolutely provide that. Additionally, even though your client may be a national of another country, doesn't mean that they don't have permission to be here. So I have had clients that were placed into removal proceedings who were in valid student visa status, and DHS just messed up. And so under those circumstances, you can provide evidence that your client does have permission to remain in the United States, and the case will also be terminated.
So once the government has proven that your client, the respondent, is removable, then I'm sorry, Jesse, you were going to talk about the convictions. My apologies.
Yeah, no worries. Okay, so we've been talking about the examples we've been using are cases where the person is alleged to have come here without permission or has overstayed a visa. But under some circumstances, when you commit a crime, if you're convicted of a crime, that can also make someone deportable from the United States. And so that will be alleged in the NTA. So under the fourth one that we saw, it'll also say, on or about such and such a day, you were convicted under NMSA 30-whatever, right, of, let's say, possession of a controlled substance, cocaine, right? And then the charge, instead of being an overstay charge, will be, you have been convicted of a crime relating to a controlled substance. And DHS will have to prove both the allegation that you were actually convicted and the charge that conviction qualifies under immigration law as a controlled substance conviction in that example. So this is one of the areas where DHS actually has some pretty strict rules about what proves a conviction. So under INA 240C3B, there are certain documents that are the only documents that they can provide to prove a conviction. They have to be, either originals, they have to have some sort of authentication that have to go with them. And so I would, if you ever have a client who is being alleged to have been convicted of a crime, in my opinion, it's complete malpractice if you admit that conviction without requiring DHS to prove it. And so that's where you can find those requirements and really hold the ICE attorney's feet to the fire to provide proof of a conviction.
And that's about 3 to 4 hour CLE on its own, determining whether possession in New Mexico that's different than possession in Texas, Colorado, Arizona. You're looking, as an immigration lawyer, you're looking at 50 different states. You're looking at federal law and how it compares the state law to the federal law in order to determine whether or not an individual is removable or whether or not a conviction for an aggravated felony or crime involving moral turpitude exists. It is a very complex analysis that you do go through. And Ms. Ashley asked about the allegations not being complete on the notice to appear. DHS has more protection in that sense, being what's called an I-261, where they're able to amend the notice to appear, add, take away, change the charge, change the allegations. We probably didn't mention at the beginning how difficult the things can be stacked against the respondent, but unfortunately it is immigration law and that's the way it is. But yeah, DHS does have the authority to submit to the court amendments to those allegations and charges.
That's right. And sometimes they'll even just do a pen and ink change with the judge there on the notice to appear. Now, is that legal? We can argue about that later, but that does happen on some occasions. So now I wanted to say briefly that, at the beginning of this, we said we wanted to get rid of some of the fear, right? So I hope that we're not scaring everybody by saying, oh, it's more complicated and there's this other CLE. This is what I will say regarding removal defense. So before we get to the relief phase, right? If this is your first immigration case and the guy comes to you and he's got a conviction for something, you need to call somebody who's done one before. That's what I will say. And there are many, we're very lucky in that the immigration bar in Albuquerque and in El Paso is very helpful to one another. I think we all recognize that we're all on the same side and we want to help other people. So I am, always available for you guys to call. I know Daniel's available to do that, and particularly on criminal issues. I handle the Office of the Public Defender for the state of New Mexico and advising on that stuff. So I might be able to answer your question in a very short amount of time, or I can take a longer amount of time. And when I don't know the answer, or if it's a Texas conviction, I go to Daniel because he has a really good working knowledge of the Texas statutes. So if it is a conviction, get help for sure, okay? I want to make a quick note about bond proceedings in immigration because it always comes up, but we're not going to go into a lot about bond. And the reason for that is that there is a separate CLE that is being taught by Imelda Maynard of Catholic Charities of Southern New Mexico, I believe in 2 weeks. She's going to go all through the bond stuff with you guys. But a quick note is that bond proceedings, or as we call them, custody proceedings, are, unlike with criminal cases, they are completely separate from the removal proceedings. And when I say completely separate, I mean completely separate. There are 2 different files that they use for the same person. One is your removal file, one is the bond file, and you cannot take documents from one of those files and put it in the other without permission of the respondent, okay? Or they would need to be resubmitted in the other case. They also, those hearings are completely separate. There are separate records that are kept, and many times they occur on separate days. They can occur with separate judges. Now, in El Paso at least, many times they end up with the same judge, and some of the judges will try to do your bond hearing on the same day as your master calendar hearing, but you can't count on that. And this is really important to talk to your client about as well, because as an attorney, you have to enter appearance on either one or the other or both. You have the option of only representing someone in bond, only representing them in removal, or representing them in both. And that's an indication you would make on your entry of appearance. I did want to note, however, that in this designation, which we talked about, you do want to see whether or not they're an arriving alien. Okay, so it says here, if they're designated as an arriving alien, right off the bat, you can tell your client that they are not eligible to ask for a bond. Okay, and Imelda will go more into detail on that. There's also INA 236C, which deals with mandatory detention. So again, unlike criminal proceedings, immigrants do not have a right to bond. And under certain circumstances, if they've been convicted of certain criminal offenses, they are not eligible to request a bond from the immigration judge. He just doesn't even have jurisdiction to consider a request like that. So those are the questions that you will definitely get asked by a client. Okay, Daniel, tell us
Okay,
about.
so once you're found to be removable, or you the judge has determined that the government has submitted sufficient evidence to support the finding that you were removable from the United States, then you get to move to phase 2 of the immigration court process, which is, are you eligible to remain in the United States or not? Are you eligible for some form of waiver or relief from removal? There's a number of different forms of relief going back many, many decades. The immigration law has changed many times, but not significantly for the last 20 plus years. We mentioned here LPR cancellation, which is cancellation or removal for immigration for immigrants. And so in those cases, for instance, a lawful permanent resident who's been in the country for more than 5 years, who hasn't committed an offense that makes that individual removable within the first 7 years, and who is not an aggravated felon, would be able to apply for a once-in-a-lifetime waiver from removal. Additionally, there's relief available to individuals who might have more time in the United States, who also have good moral character, and who are able to prove something that seems almost impossible, which is that they have a qualifying relative that's going to suffer exceptional and extremely unusual hardship. Those are standards and factors that weigh very heavily. On top of the statutory eligibilities, they also have to generally prove that they merit a grant as a matter of discretion. So discretion is very important to remember. There's a lot of protection for individuals who have suffered or been victims of a crime, individuals who've been victims of domestic violence, such as VAWA, the Violence Against Women's Act. An adjustment of status is where an individual can change their status from that of a tourist to that of a lawful permanent resident through a family immigrant application. Oftentimes, a voluntary departure is not seen as a relief from deportation. That individual still has to leave the country, but at the same time, it does not have a legal, it doesn't carry the same legal significance as a deportation or removal order. And so it can be helpful in many cases. There's statutes that are very old, such as INA 212C, for offenses that were committed before 1996. And believe it or not, there's still a number of cases that arise, specifically lawful permanent residents, who have very old cases. Over the last probably 6 years, the Department of Homeland Security has gained more and more access to the criminal database, and they're able to find more individuals that have very old criminal offenses. That statute itself has been subject to tremendous litigation. There's fraud waivers, and then of course asylum, withholding, and protection under the Convention Against Torture. Asylum itself is one of those things that carries a very, it requires a lot of knowledge and learning. It's not a case that you take on right away without some help. as Jesse mentioned, because it can be not only intimidating, but more importantly, you want to make sure you do it right. And in most of those cases, it's not something that can be uh, easily done without a little bit of experience. Removal proceedings are very, as I mentioned, very informal, and so are the rules. The rules of evidence, such as hearsay, different things that you may be used to in criminal court, are uh, not applied in removal proceedings. Testimony, credible testimony at least, is taken in from different witnesses. The government can often meet their burden with a document called the I-213, which is a record of removals. Um, that document has the ability of the individual to uh, the government presents this document and it's on its face, it's considered credible, even though the officer that has authored that document is not present. That's a thorn, I think, in many of our backsides, is that it seems that many times evidence is admitted as long as it is reasonable, as long as the judge sees it, and the judge can give different pieces of evidence different weight. And so when I prepare for an individual hearing, a trial per se, what we do is we submit lots of statements, affidavits that have to be either notarized or under penalty of perjury. We submit a lot of documents. There is no tracing or proving the whereabouts of those documents as there is in many criminal court proceedings. You're not following documents. There's a lot of credibility given as long as it's reasonably presented. Subpoenas, as Jesse mentioned earlier, are absolutely possible, but they're not, again, they have no teeth. And so if I subpoena an office or a teacher or someone, an individual to come give testimony, it's not always the case that we're going to be able to get those. I think Jesse mentioned the record of proceedings in criminal court, and I saw a question regarding police reports. It's true that there is a very controlled record of proceedings for the criminal proceedings, but at the same time, for discretionary purposes, and it's got a huge umbrella. Many judges will ask for and require seeing those police reports to determine whether the testimony of the respondent or witnesses matches what the police officer alleges in their police report. Even if the police officer is not there, even if the author of that document is not there, again, the rules of evidence are not, I won't say that they're non-existent in immigration proceedings, but they're definitely very lax.
Many times you'll hear the judge say, I'm not, as a matter of discretion, I'm not going to grant your request unless I see the police report. So you decide. You decide if you want me to deny it or if you want to show me the police report. So it's a good idea to know what a police report says and to go over that with your client before you have them testify, certainly, so that you can address anything that needs to be addressed, because odds are that police report might become an issue later. The other thing I wanted to add in terms of the forms of the rules of evidence is that absolutely hearsay evidence is admissible. It does not have to fall under any of the exceptions. It doesn't have to be a business record or anything like that. And what the judge will say, basically the rule for admissibility in removal proceedings is relevance. If it is relevant, I'm going to accept it into the record and I will afford it proper weight, is what they will say. And so you can kind of undercut the contents of a document, but it is going to come into the record and they are going to see it and look at it.
And if you're representing an individual in the removal proceeding, it's probably best that you address those negative issues instead of allowing the Department of Homeland Security to do so. Take the lead on it so that you can direct how you want to explain that. Now, I will tell you, immigration court proceedings are unlike anything that you are likely going to be used to. They oftentimes you can be going through examination, and the the judge will interrupt with their own questions. There are some judges that like to question the respondent first in these individual hearings, and they like to elicit answers first before moving on or allowing you to do rebuttal. Usually you'll do your direction and then cross from the government, and then the judge will also ask their own questions. So it's definitely there are three parties in that courtroom that are asking questions of witnesses and or respondents. There are two different types of individual hearings or merit hearings. One is whenever you contest the removability. So for instance, the allegations in the notice to appear say 1, 2, 3, 4. 4 is whether or not you are deportable from the United States based on New Mexico is a good one. Abandonment of a child in the state of New Mexico. And I don't have the statute number, but we've argued multiple times that that statute is divisible, meaning part of it could make you removable, part of it could not. And so the courts will generally schedule a contested merit hearing so that the issue of removability can be determined in that process first. And then you move on to individual hearings. Too often, there's attorneys that concede removability without any contestation. They admit, well, this is the guy qualifies for cancellation or removal for a waiver. I might as well just go ahead and move on to the relief part. But remember that that's a once in a lifetime waiver, and that if you concede that too quickly without, again, putting the government's feet to the fire, improving that the statute that they were convicted of is a removable offense, then you're taking away that individual's future chance at a waiver if that should become necessary in the future. And there's never a guarantee that a judge under discretion is going to grant your waiver to your client, even if you are statutorily eligible for it. The courts are managed by what's called the Immigration Court Practice Manual. They are and they are not. So that manual was elicited in 2008, I believe, and it was drafted and created. It's been changed numerous times. And recently, the Attorney General has issued instructions that it doesn't always have to be followed, and judges have a little bit more ability or power to make decisions based on that. The judges have the authority to set deadlines. Many judges have standing orders that require more or less than other judges, more or less in the practice manual. But start with the Immigration Court Practice Manual. It's a very thorough document that allows you a view of what you're going to be submitting, how you're going to submit it, deadlines, standard deadlines for evidence and things like that, bond proceedings, appellate proceedings, and so on. And at these hearings, these individual hearings, where you're asking for relief, you're oftentimes going to have testimony of the respondent and any witnesses that you feel may be beneficial.
Yeah, I wanted to say, just as a practice pointer, to take advantage of the informality, I think, of immigration proceedings, and particularly with judges here in El Paso and in Otero. They're human beings and they're friendly to the attorneys. And so many times I will ask the judge and say, Judge, I've never done one of these with you before. How do you normally like to proceed? Do you want to do the questioning first? Do you want me to do preliminary questioning? How would you like to handle it? And they'll tell you. And they'll tell you also, when you're at your master hearing and you're setting up for your individual hearing, I'll do the same thing. I've never done one of these with you before. What types of evidence do you normally like to see? Do you have any requests? Some judges really like to have written declarations that are very detailed, and you can comply with that as much as you want, but it's good to know what they expect. The other thing that I'll mention is that some of the judges now limit the amount of documentary evidence that you can provide in an order. And that's what Daniel was talking about with the new Attorney General, kind of emboldening judges to restrict the record. I would just encourage you, if you come up against that, to contact someone like myself or like Daniel on how to maneuver around that, because number one, I don't think that that's totally legal. I think that you can definitely challenge that if it comes to that. I think it's a great appellate issue, but at the same time, because these judges have so much discretion in granting relief, you don't want to piss off the judge, right? You need to kind of be careful in how you approach issues like that. Okay, I'm going to go over a couple of procedural issues, and then we're going to move to questions. These are just questions that I get all the time from attorneys that are used to more stringent civil rights in proceedings. So service of process in immigration court, personal service is can be achieved through mailing. Okay, so if they mail you a notice of hearing, whether or not your client receives it, it doesn't matter. That counts as service of process. Okay, in terms of changes of venue, you can file a change of venue. Generally, the rule is, and you can look at, matter of Rahman for the factors and everything, but generally the rule is if they're not detained, those will be granted as long as you're asking for the venue change to reflect where the person lives, right? So if I get a client out on bond and they move to San Francisco, we can request a change of venue to better to the court in San Francisco. Now, I've had clients that are going to move to Oklahoma, right, where maybe they don't have as a liberal of a judiciary there, and they'll say, can I change venue to San Francisco? No, you cannot. You have to change venue to where you're going to live. If your client is detained, they are not going to change the venue. Doesn't matter if they've transferred your client. Doesn't matter if they were arrested in San Francisco and then they get detained here. They will not change venue back. You can certainly try until you're blue in the face, but it doesn't really happen. And then administrative closure is something that we used to be able to do. It was a procedural tool for judges to be able to use. It's in the regulations. I think is it in the statute? I don't remember. It is in the regulations, and it's kind of like a docket management tool. Then the Attorney General in 2008 came out in matter of Castro Tum and said that judges no longer have the authority to manage their documents using that tool. That is being challenged in different circuits, and so in the 4th and in the 7th Circuit, that's still something that exists. But that may be something that someone tells you. They may say, I was in removal proceedings 5 years ago, and then it just went away. We never went to trial and they're just gone, right? That might be an administrative closure that happened under the Obama administration. In terms of continuances, you have to show good cause. And there's all this great case law that talks about the factors that you have to provide, they have to show in order to prove good cause. And then the Attorney General in 2018 again came out with matter of LABR, and he basically said, judges, be really careful with that good cause. You guys are granting too many continuances. And so the judges now are a lot more strict about continuances. And this is important because, for example, if your client qualifies for something outside of immigration proceedings, like a U visa, right? Because we're a victim of a crime, and that's going to solve their problems. They're going to get the U visa, they're going to get their residency. And so what's the problem, right? If you go into immigration proceedings now and you ask for a continuance based on that pending U visa, matter of LABR seems to say that they can't grant it anymore. Okay, now you can still argue. There are some things, if you come up against that, contact me or Daniel, and we'll talk about it. But matter of LABR really restricted the circumstances under which judges can provide continuances. All right, do you want to talk about questions and then we can move to questions?
Yeah, we're running short on time, so we'll be really quick on this. If you're not successful in your proceedings or you don't get what you're asking for, there are different things that you can follow, such as motions to reopen or motions to reconsider. The rules are up there. We won't go into a lot of detail. You have 90 days for a motion to reopen. You have 30 days for a motion to reconsider. Each has their own standard, whether it's new evidence or based on new law. But the more common, I think that item that you're going to go to is an appeal to the Board of Immigration Appeals.
Yeah, so no, when you're talking to a client, you need to know when their order was entered, right? You need to know when the last time that they had a case and they were ordered reported. And then you want to remember 30 days and 90 days are important deadlines that you need to be on top of things. So making sure you're calendaring that, or you're making a note of that, you're investigating things, because your notice of appeal is due in 30 days. Your motion to reopen, your motion to reconsider is due in 30 days, and your motion to reopen is due in 90 days. Sorry, go ahead, Dan.
No, that's okay. The notice to appeal goes to the Board of Immigration Appeals. They'll send you a record of the proceeding, a transcript, and a order for briefing, a briefing schedule. They're trying to reduce the amount of time that those are pending. So be prepared to move forward with those as quickly as possible. Under this administration, they've also limited the continuances or extensions that they're offering, that they used to offer for briefs and so on. The Board of Immigration Appeals is changing significantly again under this administration, but it is where you get to argue either errors in fact or decision, discretion, questions of law, and you see the standards of review there on the slides.
And then if all else fails, you can try to go to the circuit court. There are some limitations to that, but it's important to know that you've got 30 days to file a petition for review in front of a circuit court. And you must also be aware that that does not stay removal of your client. So once you lose at the BIA, your client is removable at that point. They're in detention. They may be removed very quickly. So you may have to file an emergency stay of removal with the federal circuit court that you filed your PFR with. The other thing to remember is that in order to do your PFR and for it to be successful, you have to exhaust your administrative remedies. So that's why those motions to reopen and reconsider deadlines are super, super, super important. And you need to make sure that you're logging those in, you're advising clients. And then finally, there is no review of discretionary decisions. So just know that under IRA, and then also under EDPA, which I know a lot of the federal criminal attorneys have to deal with as well, there's some jurisdiction stripping provisions in both of those laws that really narrow the scope of what you can bring in front of a federal court. So let's see if there are any questions in the last 2 minutes that we have. I'm also happy to stay on if folks have other questions.
Esther asked if your client had entered a nolo contendere or no contest plea, how is that viewed by DHS?
It is absolutely a conviction.
Yeah. So in immigration court, a conviction requires a admission of facts or a finding of facts sufficient for a conviction, and a punishment or some form of punishment by a judge or court. It doesn't take much to become a conviction. A deferred adjudication is a conviction for immigration purposes. And until about 2 years ago, we all felt very comfortable with the pretrial diversion, but Matter Mohammed in 2018 kind of changed that, or turned it a little bit, removed a part of that. Very few of those cases, but if you're a criminal practitioner and you don't know if the individual is going to be removable or not accepting a plea, make sure you speak with an immigration lawyer, or have the client go out and hire their own attorney their own immigration attorney for that review and analysis.
Shorthand for New Mexico is that a conditional discharge is absolutely always going to be considered a conviction. And PPD, the way that it is practiced in almost all of the state, I think San Juan County has some weird ones, but PPD is not going to be a conviction, most of the time. But still, if you have a question and your client is indigent, you can request me to provide that advice specifically to your client.
Questions, anyone else? Okay, so Patrick, I think we'll turn it over to you.
All right, well, thank you very much, and thank everyone for attending. this was very excellent. And so I did provide my email in the chat. Again, if you didn't get it, it's lopezp@law.unm.edu. Email me if you would like the slides or if you have any other further questions regarding the presentation. And with that said, thank you all. Thank you for coming.
Thank you, everyone. Thank you for having us.
Thanks, guys.